When a life insurance company requires written notice before the assignment is effective, does that deprive the party who failed to provide that notice with contractual right to sue? To find out, you have to read Brettler versus Allianz Life Insurance Company, but it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Brettler versus Allianz Life Insurance Company. The citation for this case is 2023 New York Slip Opinion 05958, published by the New York Court of Appeals on November 20th of 2023. The issue in this case is whether, in a circumstance where a life insurance policy provides that assignment is effective only upon notice being given to the life insurance company, and that notice is not given, does the failure to provide notice deprive the ultimate assignee of standing to sue the insurance company? To understand and appreciate the context of this case, basically, you have to understand that there's something called an anti-assignment clause, and in New York, they're very, very strictly construed. New York does not like anti-assignment clauses generally, and so in New York, for an anti-assignment clause to be valid, which would basically deprive a person who has this policy of being able to transfer to another person, it has to be the language they use. It has to be the clearest language and the plainest words. If it uses the clearest language and the plainest words, saying that an assignment is in contravention of the contract, then and only then is an anti-assignment provision valid, and then an assignment is void. But in the absence of that, then an anti-assignment clause is not valid. But the facts of this case are that in 2008, Allianz Life Insurance Company issued an $8 million policy on the life of Dora Zupnik. And the beneficiary of that policy, the owner of the policy, was the Zupnik Family Trust. So if Dora died, the Zupnik Family Trust would get $8 million from Allianz Life Insurance Company. The provision of the policy, there was a provision that said the owner could assign the policy, but it was only effective. The assignment would only be effective upon notice made to Allianz, which was later defined as satisfactory written notice in the policy. In 2012, so 4 years later, the trust sold that Zupnik policy to someone named Miriam Mushel. So the trust then assigned the policy to Mushel, who notified Allianz of the transfer. Okay, so they're compliant with that notice provision. In 2013, Allianz put the Zupnik policy in lapse for non-payment. And then 3 years later, Mushel sold that policy back to the trust in a written agreement. But no one ever notified Allianz of the transfer, of the assignment. So then Brettler, the trustee of the trust, sued Allianz, seeking a declaratory judgment, seeking basically a determination from the court saying that the policy does remain in full force and effect, and alleged that the Allianz company was in violation of their rules because they did not properly notify the owner of the policy of the lapse. They didn't give him they didn't give him the written notice that was required under the policy. And in response, Allianz files a motion to dismiss saying, we don't even know who you are. The trust, which originally was the owner of the policy, as far as we know, Allianz says, Mushel is the owner of the policy. They were assigned it and they gave us notice. And if Mushel is now saying that they transferred it back to the trust, I don't recognize you as the owner of trust. So they move to dismiss and they prevail. At the district court, they prevail, granted the motion to dismiss because of that lack of notice that was given to Allianz. The district court says the trust lacked contractual standing to sue because Allianz never received that notice of the assignment. It gets sent, this is in federal court, it gets sent to the Second Circuit Court of Appeals of the federal system, and they send it to the New York Court of Appeals to certify the question. They say, under New York law, what is your position on this issue? And the New York Court of Appeals says, first of all, they go through whether this is an anti-assignment clause, and it's not. They say an anti-assignment clause, it doesn't have the clearest language and the plainest words. And second of all, they're not saying you're not allowed to assign it. They're saying you can assign it. They're not depriving whoever owns the policy of assigning the right, but they're saying if you do assign it, we are not bound unless you give us written notice. And what that is what's called a condition precedent. So the condition that must be accomplished before Allianz can be held to be responsible and actually have to pay out or comply with the contract and the policy is that written notice. So they say this is not an anti-assignment clause. It's a condition precedent that has not yet been accomplished. So absent notice, they say, Allianz is not bound by Mushal's assignment. They're not saying the assignment didn't take place. The assignment took place. Mushal sold it to the trust. All that stuff took place. But Allianz is not bound until and unless they receive written notice as per the notice provision. And that's the holding of the case of Brettler versus Allianz Life Insurance Company. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.